My name is Jacqueline Kagume, and it is my absolute pleasure to welcome you to our discussion today. Thank you for being here and for showing your interest to participate in this discussion. So the Institute of Economic Affairs is a public policy think tank, and our mission is to inform decision-making in Kenya through policy innovation, research, and dialogues. We work across 6 program areas on public finance management, on economic regulation, competition, and competition policy, popular economics, futures and foresight, international trade, and constitution, law, and economy. So these are our 6 program areas, and today the CLE program, where I work together with my colleague Leo, is hosting this discussion. As you saw from the title of our meeting today, we are here to discuss critical issue that's basically from our assessment at least. So the CLE program of the IEA has been studying a number of issues around the functions of the judiciary, the operations of the judiciary, and other constitutional bodies. And for the judiciary in particular, the issue of case backlogs was important to us because it has a big implication on the dispensation of justice. So we conducted a study, and today we'll basically be sharing some of our findings with you to unpack that issue of the growing unresolved court cases in Kenya. And basically, our study was from a political economy analysis lens. So looking at the institutional, political, and economic dynamics that contribute to the persistence of the issue of case backlogs. So we have prepared a presentation, my colleague Leo and I, who work in the CLE program, as I mentioned, and we'll be making this presentation in 2 parts. I will begin with the first part, and then Leo will come in. So before I talk about the outline, just to remind you, in case you have any questions as we go, please note them down. We have a chat box facility on this. We'll allow you to ask the questions or contribute if you have any divergent perspectives from what we will share here. We will allow you to contribute to the discussion and to ask any arising question that might occur as we go on. So please feel free to use the chat box on this platform as we go. So we go directly to the presentation, and this is our outline. We begin with an introduction, so the context of case backlogs, and then look at the main policy concerns in a little more detail. Then we will discuss the PA questions that drove our study. So basically the driving institutional and other dynamics that drive the persistence of case backlogs in Kenya. We will talk about the question of adjournment in a little more detail. We will talk about the extent of case backlogs, the case disposition rate, different scenarios, our peer analysis, and key messages. So in about the next maybe 50 minutes or so, or an hour or so, we intend to have dispensed of that agenda. So we go to the main presentation itself, and I'll begin. So when we started conducting this analysis, we looked at, first of all, what's the definition of case backlogs. I think all of you probably know it's case backlog refers to cases that remain pending for a period that is longer than what is acceptable, or that is longer than timelines that are prescribed in different jurisdictions. So for our Kenyan context, we define a backlog as a case that remains unresolved for a year after it's been filed. And the reason that this is a problem is because there's a constitutional requirement under Article 159 for the dispensation of justice to be expeditious. So if you read Article 159 2B, you will see that it states that, among other things, that justice shall not be delayed. And this is emphasized under the other provisions of the Constitution as well, the chapter on the judiciary. And also, if you look at the acts of parliament that concern the operations and the functions of the judiciary. So the very idea of the issue of case backlogs is basically at odds with this constitutional obligation, and usually ends up causing various issues from prolonged uncertainty over provision of rights and obligations, basically in terms of when there are questions regarding interpretation of rights, questions regarding obligations, various obligations, which causes financial strain on litigants, because obviously the more prolonged an issue is, the more expenses accrue with regards to the litigation process. And it also, more often than not, leads to compromised outcomes due to erosion of evidence over time. So that's the first in the first sense. Then the other thing is that the Constitution basically creates an obligation to act for the state and for the different stakeholders mandated to ensure the expeditious dispensation of justice. So from our study, some of the policy options that we consider feasible basically to address the issue, and this will come out in a little more detail later when we're talking about the policy recommendations. Some of the things that could be considered to prevent or to address the question of the case backlogs is either increasing the judicial resources, that's in terms of the different categories of resources that are required to ensure the smooth administration of justice. So judges, additional courts, that's the courts infrastructure, and whatever other relevant infrastructure is required. Another valid option would be streamlining case management. That's in terms of technology. And recently you've seen the judiciary increasingly take on more try to prioritize the digitization of various functions of the courts, and then also promoting alternative dispute resolution that could be mediation, arbitration, and so on. And this is actually also provided in the Constitution as one of the things that should be considered under the chapter on the judiciary. So just to reiterate, a summary of the implications of the case backlog problem is that these case backlogs hinder access to justice, prevent enjoyment of economic freedoms and democratic growth. And this, in effect, from our assessment, leads to denied justice because, as you know, justice delayed is justice denied. So that's that. So next, one of the emerging issues, this is still part of the background, one of the emerging issues from our analysis of the persistence of the case backlog issues, we found that there are some significant regional disparities in terms of case filing. And that's looking at it geographically, so the distribution of how cases are filed across the country. We got some interesting findings. So for instance, over 50% of the cases were filed in 11 counties only out of the 47. So that shows that even the persistence of or the occurrence of the case backlog issue, or the persistence, the main contributing factor could be rather there's cases that are filed, there's a disproportionate filing of cases across the counties, with, I think, obviously the larger counties bearing the larger share of the cases that are filed. And what was of interest for us here was, so does the distribution of resources to dispense of justice in these regions match the filing of the cases, and Leo will tell us more whether this does or not. So Nairobi alone had 110,374 new cases, as was reported in the State of the Judiciary and Administration of Justice report of 2023-24, which is the last one that we looked at. And rural counties, again, for obvious reasons related to the population density, seemed to have or to reflect lower number of cases filed. So from our assessment, this would suggest a need for equitable resource allocation to address the issue. But we'll come to that later as to whether this is done or not. So then another issue of concern was the adjournment crisis. So as we are trying to study and understand this problem, we found that not only is the problem particularly with regards to how cases are heard and the writing of the decisions and so on, but there is a serious problem related to adjournment. And here, there are both external and internal causes that lead to this, and I'll explain. So, but first, we found that there were about 210,592 adjournments in 2022-23 alone, which would translate to about 4,000 adjournments per week. And as I've mentioned, so we have the adjournments occur for a number of reasons. So the external causes of the adjournments accounted for about 67% of all adjournments. And these are the ones that are classified relating to absent parties, unprepared prosecution, unavailable advocates, and so on. And then we had internal causes, and these are the causes that relate to the court itself. These include indisposed courts, unprepared judgments, non-sitting courts, and so all the ones that relate to the internal causes were about 33% of this. So again, this implied to us that there's need for targeted reforms in terms of the judicial scheduling, resource allocation, and also the change of norms to also address why we have such a high persistence of adjournments that relate to the external factors. And so this next slide basically disaggregates the reasons for adjournments that I've just spoken about. So we had the reason for adjournment on the one side, and then the type. So parties not being present already. So we talked about this being external, witness, experts not, or reports not being ready, external advocates not present, and prosecution not ready. So the 67% there. Then the court being indisposed, judgments not being ready, and courts not sitting, 33%. So this was as reflected in the SOJA report of 2023. Then we use so in our study, we use the incentive theory to explain why backlogs persist. So from our study, we found that court efficiency usually depends on aligned incentives. And this is aligned incentives of the various stakeholders, that from the judges, the lawyers, the litigants. There must be a presence of aligned incentives to be able to prevent the question of these recurring backlogs. So we found that in our context specifically, there's an obvious misalignment of incentives. And so, for instance, judges could be or seem to be sometimes indifferent to delays, either due to understaffing, their leave conditions. So sometimes when they have favorable leave or rules to be on leave and away, then I guess they prefer to, it is not in their interest particularly to change the rules related to their leave to accommodate or to expedite the resolution of cases. Then there are factors such as political pressure. And then for lawyers, for instance, there is the issue of, we know for a fact that the longer, the more prolonged cases usually tend to higher or more billable hours. So for some of them, it is in their interest to have cases being as prolonged as possible. And then for litigants, in certain instances, they aim to evade judgment or just slow down or prevent a quicker resolution of their issues. So unless these incentives are realigned, either through institutional reform, there's likelihood that this issue of case backlogs will persist. And so the political economy issue here that we point out is that there's need for the JSC to address this question of the incentives, and that's particularly on the internal side. So the incentives related to judges to see how that can be aligned. And then we also suggest that the JSC's goal should be to align the incentives to ensure that there are no unresolved cases, basically to fulfill that constitutional mandate for the timely dispensation of justice. Then why did we choose a PEA approach to understanding the question of case backlogs? So the political economy analysis method or tool is one of the approaches that the IEA has considered useful in understanding serious, persistent economic policy and general public policy questions. For the context of case backlogs, we found, or from our assessment, it was clear that they are not just a technical problem related to courts, but they have some underlying power, interests, and institutional factors that drive this problem. So it is important to be able to find a feasible solution. It is important to understand the magnitude of the problem and the underlying or root causes of the problem, and basically to be able to have a solution that would then match the nature of the problem. So for us, we found that the PA approach usually allows for us to look at both the formal and informal factors that drive the problem. And when I talk about formal, it's basically factors that are easy to see. And this could include things like formal factors, the laws, the legislation, the court rules, the judicial structures, the infrastructure. So these are the formal things that you can see. And then the informal factors are primarily the unseen factors, and these are the underlying issues like the political interference, the question of the professional norms that allow the persistence of the problem, and the other underlying factors that shape the outcome that in the problem that we are dealing with. So that's the second thing. And then we are also dealing with the differential interests, as I've already mentioned in the previous slides. And the different interests among the different stakeholders also translates to or means that there are different incentives to do away with the problem. And so even in cases where, for instance, judges may want to reduce backlogs, there might be some pressure on certain issues. There may be understaffing or political actors. There may be instances where it is not in their interest to dispose of the issues quickly. Then again, litigants may want a resolution delayed for reasons that I've already spoken about. Lawyers, again, I've already spoken about the reasons why they may want an issue fast-tracked or not. So the PEA lens is useful to helping us understand how the different dynamics operate and what kinds of reforms are required or likely to succeed basically based on how well or not they align with the incentives to resolve the issues. And then the next thing is now the main questions that we considered. We could go to the next thing. So, and this is where I'll end the first part of the presentation. So we designed a few questions to address, having understood the broad context of the problem, the broad way in which the question of case backlogs manifest. We thought it would be issued to think about the main questions that then have to be answered to be able to resolve the question of case backlogs. And we summarized the main problems into the 5 here. And so the first one is, what factors explain the political economic constraints on the judicial capacity to address case backlogs in Kenya? Then the second question was, why has the issue of case backlog not been prioritized by the different stakeholders, given its impact on the rule of law and economic development? Then what structural and institutional factors contribute to the persistence of case backlogs in Kenya, in Kenya's adversarial system? And then 4, we had a question on how do the incentives, I've spoken about some of these, but how do the incentives of key actors, judges, lawyers, litigants, parliament affect case backlogs, either basically sustaining them. And then 5 is what political and economic forces shape the uneven distribution of judicial resources and backlogs across Kenya's regions. So how did we answer this question? I stop there and invite my colleague Leo to come in and follow with the second part of the presentation. Leo?
Thank you so much, Jackie, and for that first part of the presentation. So one thing that we need to actually mention is that we need now to understand what is the extent of case backlogs in Kenya. And one of the numbers that we looked at is now the cases that are already on pending. So if we take a very short trend line from 2016-17 and to 22-23, you see that the numbers have gone up from 300,000 to 649 within just a period of 7 years. And that growth, and you can see the pendency goes up. The trend line number goes up, only with the exception of the COVID years. The COVID years, number of cases, because of the shelter in place requirements, number of cases fell. Number of reported a number of cases filed, both criminal and civil, and also the number of reported cases to the police, amongst other things, just that number. So COVID years 2020, 21 is an outlier, but you see the general trend is that those numbers have gone up. The second number that we look at is to now see the growth in filing, the growth in pendency, the pending cases, and the disposition rate, the changes in disposition. So you see that in terms of the number of cases filed and the pending cases and the changes, you see that they've been that even growth throughout, except 2019-20, and then the number of cases pending. The number of cases pending, you see that the same. This is from the similar chart from the previous chart, and then now on one side, disposition. Disposition is now resolution, what has already been resolved. So when filed cases, when pending cases, the rate of disposition does not actually take out cases pending plus those filed. It creates this kind of a system where cases go up in hand. Just to give it an anecdote, So you see, some you go in April to courts and you don't get an hearing date in any division, whether it's commercial, whether it's issues on criminal and the others. Amongst other issues. So you see that the disposition rate has gone up in some years, like 21, 22, it's at 123%. And that shows that in that year, what we tried to look at, what are some of the things that were done in that year to help with the case backlogs. Some of them include that some sentences were reviewed as part of prison reform, as part of decongesting the prison. There are other things like some resentencing for some other there are some form of resolutions because of the decisions like Mruatetu, amongst others, that helped improve those numbers. Now, we asked ourselves, as the Institute of Economic Affairs, primarily, we use economic modeling to answer specific questions. So if you have a system that has pending cases in place, and there are more cases that are filed on top, and the disposition rate is lower than to clear those cases, what model would it look like? So you find that, so part of it is that backlog would be now a factor of cases disposed, the disposition, that disposition plus the case filing rate. Then if you see, so if you take that, when we try to use the data, we found out that whenever there is an higher disposition rate, in the subsequent year, there was a lower backlog number. And we give examples like the 177 rate, backlog went down by 240,000. 68% rate, when the rate was disposition rate was lower, a backlog went up. So there's a negative resolution, a correlation, and a higher case resolution reduces pending cases. So this number is important because it shows, it confirms what kind of disposition rate is needed to lead to certain backlog, to reduction of backlog growth. And then we modeled. So using the similar model, we're able to ask ourselves, if today Parliament asked us, or the Chief Justice asked us, what would it take for the judiciary to clear the backlog? 1 year clearance rate, using now the same model. It should be able to hear 1.2 million cases this year. And that would require a disposition rate of 204%. And then if we started to prorate now and ask what would be a more realistic horizon in 5 years, the key issue that we pick out from this is they have to hear 21% cases more than what is filed and pending in a year. So like than what is pending in a year. So for the case of the year 2022-23, where there were 649,229 pending cases, the judiciary has to hear at least 754 and conclude them and resolve them. 754,170,000 cases. So that is a more realistic and more realistic horizon, and that in essence, keeping at the same rate would be able to clear those cases within 5 years. There is substantial literature. I don't want to belabor on this, and because already these are things that are already available. Substantial evidence from how case backlogs actually impact affects the rule of law and economic development. The key issue is that predictability and certainty, uh, certainty or uncertainty. In economics, it has a cost, uncertainty, because that predictability in policy, predictability in many other issues, contract enforcement, among other things. Delays also affect crime and reliance on informal dispute mechanisms. And we see this from the northeastern, like many other places, where the aspect of security, national security, is severely affected. Economic development, contract enforcement, it compromises property rights, increases uncertainty, and uncertainty as an issue because it increases that risk premium and tying up resources and hindering the enjoyment of those property rights. Inequality in a judicial system where there's serious case backlogs, it's difficult for persons of low income to assert their own rights, and it affects. So one study or that we picked was an empirical study done by an economist in India. It showed that a slow judiciary led to contract breaches, reduced relation-specific investments, and limited access to formal finance because banks cannot already commit to their financing where there are disputes. And it led to, so in India, there's a problem of that one, it's a caste society, and there are problems that with that, because in some places, actually, there others couldn't assert, other groups could not assert their rights over the others. So, and then if you move, so one finding that he had is that in moving and from an highest pendency state with many pending cases to a lowest pending to a state with lowest pending cases, there was a 10% improvement in farm performance. And that in itself shows, and this is from now empirical evidence. Now, I don't want to belabor you. We just wanted to show this, but we considered many other institutions from already those that are formal institutions, judiciary, chief, CJ, criminal justice system actors, attorney general, DPP, parliamentary committees, and we even considered those that deal with justice issues, and JLAC, and also the budget committee, development partners, non-state actors, court users, prisons, probation, media, and others. And we see that each has significant powers and influence, but their incentives are different, are different, are different, and each has and you arrive. So we can mention, for example, very very high at a very high level. So like the judiciary, the entire judiciary, the problems of resources, problems of procedural inefficiencies, and including things that such related to procedural inefficiency related to questions now on adjournment and others. Rent seeking. Rent seeking is a big problem in the judiciary. Resource constraints, and then for the CJ, political interference, budgetary constraints, and also the JSC, political pressure, slow recruitment, amongst other issues. ODPP, evidence delays, and a coordination problem with the police, because largely the threshold, there's a clear threshold in law how charges should be approved, but sometimes those charges come, there are many other things that need to be tied up, but in the end, that because of those things don't end up being tied up, and so those are the evidence, questions of evidence delays, legal profession, amongst others. So that's the power map, that to show that just everybody has different incentives and their different constraints. And then when we look at the institutional analysis, so one aspect that I just wanted there are other unseen factors. So, like for example, all judges and magistrates are part of the Kenya Magistrate, the association. They have their own association. Everybody, including the CJ, sits in that association. It's a union, and they promote specific interests. And sometimes those interests might not be what the employer, DSC in this case, would like to see. And that you've covered in the study that will be shared. So some of the things, so when we did the institutional analysis, we now asked ourselves what affects each institution. So the JSC is supposed to drive reforms, make certain administrative decisions that actually would help improve case backlogs, issues on adjournment. Chairs JSC is supposed to be incentivized for justice access, versus political interference, union concerns, and also budgetary constraints. So in political economy, if you look at constitutionally, political interference is not supposed to be a question of fact, but in political economy, we know that is a key issue of concern. So when a union protects employees who have gone into that union. That union in itself, those interests are not aligned with the public interest question. JSC oversees recruitment, National Councils of Administrative Justice, coordination, because some of the things that can be agreed upon at NCAJ level, like questions of how cases are brought forward, actors like the Law Society, what professional norms need to change, all the other problems. ODPP, prosecutions, they should have as a faster, they should seek faster case progression, but they are constrained by evidence delays, because that investigation, finding probable cause, investigation, and any other all the other issues are with the police and not with the ODPP. That part of the ODPP is just to prosecute those questions. So we think that if these actors, all these actors, key actors, are able to assert that authoritative constitutional mandate, say, for example, like the DPP, we are not approving any charges that do not meet this threshold. And that gives pressure now to the police to bring forward cases that are certain direction. And JSC, So some of the things that JSC need to want to be seen, that's ensuring that they are employer that are as an employer and given functions powers within the constitution to be able to oversee the judiciary in a way that gives value for money for that allocation that has been given to the judiciary, and but also ensures that that efficiency question, because we've tried to search any public reports that the JSC has published, for example, an issue of case backlogs, and we couldn't any public assessments or substantial assessments we couldn't see. LSK, professional body, so Parliament. So Parliament has two aspects. There's the aspect of the Justice Legal Affairs Committee that deals now with the oversight of the judiciary and the budget side. The issue that we hear most is from on the budget side, that there is a resource problem, but we don't hear most how adjournments are affecting case backlogs, the issue of judges being sitting away from courts, all the other problems that intricately affect the judiciary. Unseen factors, patronage systems, rent seeking, cultural norms. So there's, for example, in August, judges go for summer. And in Kenya, we all know the climatic patterns in Kenya. Because this is a relic from the colonial administration, where judges came from England and they would go away for summer vacation. So you start to see this problem, that these cultural norms that and the same. So when those things interact, formal and formal and informal institutions, they create a problem, and that in itself, that you see key functions like digitization, a development funded, and digitization is a key function that Parliament should be able to fund, because that's a public good. When you look at other courts, if you, for example, you go to US Supreme Court and you're able to see a very case docket that you're able to see an entire record publicly available. Like technology has been done in a way that allows the judiciary to perform seamlessly. Those are things that Parliament should be able to. So reinforcements, professional networks, that an advocate on record disappears and a client is left on the other. So there are things that professional networks reinforce, that not just that affect that. And then the patronage system, cultural acceptance of corruption from the police, within the entire criminal justice system. And now combined effects, formal structures is supposed to provide accountability, do investments, offer solutions, but they don't because of these other factors. Then, so that in its essence is the reasoning that we that we've done. Yeah. So actors, just judges, they are incentivized for efficiency, but now face understaffing. The JSC face understaffing. There are courts that, because courts of first instance handle majority of all cases. This is the magistrates courts and high courts, and those are some of the areas where numbers of case resolution should inform policy decisions. The big issue is Parliament should be able to provide that funding, but especially on key issues. So, like for example, one of the things that we realized is if you look at the 11 counties where 45% of Kenya's population live in that, and some of them are metropolitans, metropolis. 50% of all cases are filed in these areas. Parliament's goal and GSC's goal should be that resources are able to follow where there's more that filing, those filing, the filing is issues of being away on official rules or on official purposes, issues related to how judges apply apply their discretion. Those are things that GSC needs to work and be able to limit. So some of the key messages that pendency is aside over by 113% over 7 years. And on per capita basis, 82 cases per person. One of the thing, and then we also found out that the regional disparities problem, 50% are filed in 11 counties, and Nairobi being one of the largest counties. Negative correlation between disposition rates and case backlogs. So faster clearance of cases lead to, so the rules committees within the judiciary and also the JSC needs to consider that it's not a question of resources alone. There is a resources part, there's professional norms, there are cultural questions that came from the colonial administration. So it's not just a question of budgets. It's not one of the things that comes out strongly. And if we forget anything about this study that we've done, is that we've realized that it's not just a question of budget. Another question is demography. Close to 45% of all Kenyans live in these 11 counties, and majority cases have been filed in these counties. There are also majority of those counties are metropolis, Kenya's most popular. So it leads the JSC when they are preparing budgets to think more about how to deal with this. So how to deal with this kind of demand. Parliament, and then what they also need to, how numbers needs to move. Coordination problem, and coordination problem can only be solved if the actors, so like judges saying, we can't accept cases. Like charges can only be valid if probable cause has been established. And mostly, when you look at this most of these cases, they are not established. There is a bails and bonds problem where suddenly numbers are already read in millions. If you look at the Constitution, bail and bond is supposed to be automatic, unless the state now objects with reasons. So there are things that really need to be enforced along the entire criminal justice system. So some of those things require a resolution. So one of the things that we based on that calculation, 50% more judicial officers at the courts of first instance. This is magistrates and high courts. And be able to double that number, you'd be able to see so equitable resource distribution. Cases should meet demand, and we've mentioned those 11 counties. Prioritize judicial funding, but judicial funding should be able to respond to a problem. And The question is, what is the problem? And the problem is not that more money is being added to the judiciary so that public civil servants working in that arm of government can drive in more Porsche cars or that kind of a thing. E-case management, and that needs to be universal. I know we know that there's already that digital platform the CTS is already functioning, but all aspects need to be universal. Strict adjournment rules. So non-essential limit non-essential duties, because majority of judges, if you look at complaints even on social media, majority of judges are always away on what they call official duties. But primary function of what a judicial officer is hired is to resolve cases. And that's some of them mandatory deadlines, looser pay rules, cost shifting to discourage this kind of now on the external side. You remember the chart that Jackie showed on the external side? How do you align that in agency problem where, for example, advocates are not ready, are not present, and that kind of the thing? Reinforce judicial incentives. We want the JSC to think of largely using the incentive framework. Don't because that's the only thing that guides how players act. They need to review the penal code. And this came from other studies we've been reviewing, that, for example, majority of women who are in prison are there. A significant part of those women are there because of charges related to trading alcohol. Informal alcohol in Kenya has been decriminalized. So there is a problem with how the penal code is structured. Uh, so legal aid, Parliament should be the office of public defendant to be able to help low-income litigants. We're asking also Parliament to give majority judiciary, JSC, and also the JLAC, and give this an emergency status to be able to raise the priority, this issue as a policy priority. Reintroduce vetting circles. The only way you kill rent seeking is a vetting circle. Every 7 years or every 10 years or every 5 years, streamline evidence, automate OBs, improve chain of custody, increase forensic capacity. Now, National Treasury, part of it is because that case backlog problem, if you looked at we didn't provide it here, but if you looked at the World Bank Ease of Doing Business Index, they measured these how case backlogs actually affect investment capability, and that's one thing that we want Treasury to be thinking about when they look at judicial function, which is a public good. Annual backlog studies. Now, when as part of colloquium and all these other things that are held annually, this needs to feature as a problem, that this needs to be studied. JSC also a dashboard tracking dispositions, adjournments, and data at a very high level disaggregated case. So thank you. I end at that. Back to you, Jackie.
Yes, thank you. Thanks a lot, Leo. So that brings us to the end of our presentation. And again, we've basically shared what informed our decision to carry out this study, why we picked the PE as a tool to understanding the case backlog problem in Kenya. We've discussed the policy concerns. Then we've discussed with you the findings of our study, the numbers related to this problem, and the policy, the driving factors, and the policy recommendations and proposals. So that is a summary of the presentation. So in the interest of time, I think I'll now welcome you to ask whatever questions you might have, and I'll open this up to plenary. I see a hand already by, oh, yes, so there's a hand already. So I hope they are allowed, participants are now allowed to speak. So before I allow the oral verbal asking of questions, I'll go to our chat box and yes, I'll begin with Prof. I see Professor Karuti Kanyinga has said something. He said the questions you need to add are the following, and he's given us a few proposals for how we can sharpen this. And so he says the questions are: who are the winners and losers in addressing case backlog in the judiciary? And here you should focus on the structure of courts, from the Supreme Court to the magistrates' courts, because the actors and motives are different. Then 2, who has an interest in addressing case backlog and what drives this interest? And 3, who is well placed to address the backlog but has not bothered to address the problem, and why are they not bothered? So that's a suggestion for additional questions. And then Nabutola says, is it not more than curious that the CJ is president of the JSC and at the same time the Judges and Magistrates Union? Conflict of interest? So Leo notes that. Then Migwe says link between backlogs and impunity, especially in corruption or human rights violations. So I'm guessing that the question is, what is the link between case backlogs and impunity, especially when it comes to corruption or human rights violations? So I don't know whether this is this Ndungu, an external participant who would like to ask, or is this our Ndungu? If you can unmute yourself.
Okay, good afternoon. This is Ndongo, an external participant.
Okay, thanks. Please go ahead.
Thank you so much for the wonderful presentation and the study. I commend the unit for having chosen this topic. So I just want to make a few observations. One of them is the focus of the study. The study has focused majorly on what the judiciary or the arms of government are doing. I would also want maybe to have a deeper look on the court users, the other court users other than the judiciary, because most of the times the magistrate or the judge might be there, but the witnesses or the correctional services have not brought in the witnesses. The lawyers are making adjustments. That is playing a huge role based on my experience. That's an area that also needs to be delved into deeper. In terms of, you brought in a very interesting observation that majority of the cases are in Nairobi, but then you find that the judiciary is seeking funds to expand or to decentralize to almost all the counties and almost all the sub-counties. Again, that needs to come out very clearly for this study to inform the judiciary in their quest to decentralize. Where should we allocate resources? Thirdly, although the study has focused majorly on what the judiciary is doing, we need to bring out the element of the impact the issue of case backlogs is having to the economy. If you look at the current budget that will be approved for next financial year, there's a section that talks about the legal dues that the government is incurring as a result of case backlog, because the minute an issue is in court for 5 years and there's an interest bit of it, that brings in a huge budgetary implication to the country's budget and, of course, to economic development of the country. And lastly, maybe I would also love to get an understanding of there's somewhere you mentioned about civil vis-a-vis criminal cases. This backlog of cases, maybe an analysis, is the majority on the criminal element of it or the civil? so that we know where to target majorly. Thank you so much. Asante.
Thank you. Thanks, Ndungu. We've had your question very clearly. Would anyone else like to verbally ask a question? Please raise your hand. Is there a hand up? Anyone else who would like to ask a question? Yes, Ayodo. Please unmute yourself and let's hear your question.
Okay. Thank you very much for the presentation. I just have a few comments. One is consider categorizing the age brackets of the cases we are dealing with, especially on the criminal aspect, because one of the key contributors to the criminal backlogs is what we call the supply line arising from children's services. So if you are looking at the criminal justice system and you go to the children's services, you'll find that it is grossly underfunded. That is one. Two, it goes back to the discretion that was talked about, where petty offenders are then locked in for an offense that would cost the government more money than even if they were released on bail. But I think there's an element of legal aid that was talked about, and in my understanding that there is a function under the state law office on legal aid. What then we should be asking is, how well is it funded, and what is the degree of awareness among members of the public in terms of the services that they offer? Then I would want to add on a comment on the penal code. You may want to do a comparative analysis of the coverage of a penal code versus what you consider best practice UN. And you'll find that our penal code is very thin, and that allows for what is normally used as other charges and offenses, and some of the examples that were given. So that is one area of review. But my concern is that in all this, the focus on the competency of the human resource in the justice system is not, in my opinion, adequately highlighted. Why I'm saying this is that we have in the judiciary legal and paralegal, and that goes to the other actors, the police, the prosecution. So if you look at that chain, there are weak links in terms of skill levels, and that needs to be addressed. And purposely, part of it was why the NCAJ was brought in to do a coordination, so that if we were to determine how many of the actors in the system have the competent staff to be able to deliver, and that goes to even the performance management system. Why are the performance management system not bringing out weaknesses that are internal to the performance of the staff that contribute to the backlog that then should require corrective action? Thank you.
Great. Thanks a lot, Ayodo. So I think we respond to that round first, then come back and get another round of questions. If I could start with Prof and his suggestions. So first of all, I agree with his proposals for additions. I think those are very valuable additions in terms of the questions that we could add to sharpen this study. I do feel like one of the part of it is already addressed maybe indirectly in the way we framed our question. So the bit on who benefits or loses from addressing the backlog issue, who has the power but lacks the will to act. I think these parts are indirectly addressed in our current framing. So where we asked how the incentives of judges, lawyers, litigants, and parliament shape the persistence of the backlog problem. I think our framing already touched on that idea of the differential interests and yes, basically who benefits. But that said, I completely agree that we might need to explicitly unpack the different basically looking at the entire structure of the courts, from the Supreme Court to the magistrates' courts, the way you've said it, and basically name the winners, losers, and all those reluctant actors. So that's something we will consider doing, or we will do as we continue to refine this study. And yes, thank you very much for that addition. Then Wafula had asked about, had talked about that question of conflict of interest. I think, again, it's another important question. So indeed, we see that dual role of the Chief Justice as both the president of the JSC and also the head of the Judges and Magistrates Association. It obviously does raise some potential conflicts of interest, especially if you think about it in the context of where performance, accountability, and things to do with the disciplinary matter are concerned. The only challenge I see is that this arrangement in terms of these functions is rooted in the design of the Constitution. So the CJ as the head, obviously, of the JSC is rooted, has its roots in the Constitution itself. I suppose the intent here was to ensure the coherence of the judicial leadership. But yes, I see and I agree with you that it is likely to cause some potential conflicts of interest. And this is exactly what we are saying, that when we study the political economy analysis question around different issues, for instance, what we are looking at here, then we're able to see the underlying flaws, either that some may be rooted in institutions, including our very constitutional design, as you've pointed out. And so we can now begin to think about how, what solution can be designed to address this problem. And Leo can also add to that response. And then there were several questions and suggestions from Ndungu with regards to the focus on more. We have focused a lot on from the perspective of the judiciary, and he'd like to hear from us on more about the role of other users. I think we've already acknowledged that the persistence of the issue of case backlog in Kenya can be looked at from two different angles. We looked earlier when I was presenting and talked about external and internal factors, for instance, that contribute to the adjournment of cases. I think we demonstrated that indeed there's a higher percentage of factors that are external that lead to this adjournment. But our primary focus in terms of looking at how the judiciary could address or fast track the issue is because of the constitutional obligation that is placed on the institution under Article 159, and the role of, basically the role of the institution of the judiciary in addressing the policy questions that facilitate or enable, I'm sorry if there's background noise, but I hope you can still hear me. So the judiciary has that constitutional obligation to address the persistence of case backlogs, from the design of police incentives, from and as well as Parliament design of legislation and so on. And then Leo, you can comment on the bits on allocating of resources. I think yes, it is concerning that despite the fact that almost half of all the cases are highly concentrated in certain regions, it does not seem to inform the direction of resource allocation. And we've seen this in that expansion. So I agree with you, Ndungu, in that respect. We'll provide a response in terms of what proposal we'd be making here. And then to Ayodo's question on the focus on the competency of the human resource within the judiciary, and also the questions around the penal code. I think I can stop there and ask Leo to attempt some responses, and then I'll come back in case we miss anything. So Leo, please go ahead.
Yes. So I'll start from the question by Ayodo. And the question is we were asking ourselves as part of this constitutional law and economy program at the IEA, we try to address constitutional imperatives. So what is the agency? What is the constitutional solution to an agency problem? So we started from where there is the agency problem. So the agency problem is that 159 on the question about justice, and that's why you see. But in the power map, when we'll circulate a study there after this. In the power map, we featured including court users. But I agree, we need to look at that question more broadly, what we've already featured. And that also applies to, even though we did not name the winners and the losers, we actually featured largely, if you look at the entire cases that are already considered backlogged, or even the filing rate, they are in the courts, what we call the courts of first instance, which is the magistrates court and the High Court, and the High Court. High Court serve as matters of courts of first instance, especially some questions related to review, judicial review, and others. So that's why we didn't take a deep dive, but we'll. That's a very good place to do, and that's yes. We've also featured who is well placed to address the backlog, but has not bothered to address the backlog, and then we featured the interest reform focus, who has the largest interest, and but does not. And that's why we featured all those agencies. We agree, especially the question from Migwi, that the linkage between backlogs and impunity, it's substantial, and that's why you look at adjournments. Even if you search on the Google platform, what is the price for for adjournment or price for an injunction, you will be able to see. So there is a clear link between impunity and from all government, and also from private actors, and especially organized private actors where there is significant interest. And so there is that clear link between impunity and impunity. On the question from Ayodo on performance, that's why we called for the only way you'd be able to address rent-seeking performance questions is to have a vetting cycle, that every 5 years you have to vet, and you vet not just with because the Constitution requires that a judicial officer be a distinguished, an academic, either an academic or some high level of distinction. Any public servant, civil servant, have some very high level of distinction. So you have to have that vetting bill to confirm that, because we've had very scary stories, like some judges have judgments that actually, as long as they've not written judgments for a very long period of time. If you look at the ombudsman report, the one touching on the judiciary, you'd be able to read very scary things, such as, including others where judges end up with property that in an issue that they were deciding, or others being executed. So like you read, so that you can only deal with that problem if you have a vetting cycle. Every 5 years of service, you have to be vetted. Even we are a as a republic, even our politicians are always out in every 5 years. So that's one of the proposals to answer Migui's question. If we are the year of the Attorney General occupies a very specific role, which is to look at public interest questions. You are the Attorney General, you're the lawyer for the Republic. So part of the thing is that vetting, dealing with that vetting, the vetting cycle, the vetting, dealing with issues of rent seeking. That in itself, for the Chief Justice, it's the administrative questions, practice directions are done by the Chief Justice. They can make tighter. The Chief Justice can make tighter rules on practice directions. How do you approach an issue where, for example, a litigant has 20 advocates, but fires every one advocate on the record every time the matter comes to the lead advocate on the record every time a matter comes for hearing. So there are things that the Chief Justice can do administratively as the head of the judiciary, and there is the other act of the Chief Justice now as the chairperson of the JSC. The JSC has to correct those incentives. And the JSC can only do that if they think about it in a way. So like, for example, one of the most problematic questions now is courts being indisposed, and they are not sitting being indisposed for a period of time, for example, on issues of going on official capacity. That's something that the JSC has to stand on its ground and say. So we can categorize, maybe, and we can follow up if you have a specific interest. Jackie and myself will leave our emails on that so that we can send a more concise summary to you. But the idea is generally that the 3 policy recommendations on either side, because the Attorney General has a different incentive from the CJ. The public interest incentive is that disruption in the judiciary has to come, and those favorable leave days, official duties, all those manner of things that actually courts being indisposed, coming up with tighter rules around court processes, and thinking about those rules in broadly. That is something that can only so the looser pays rule proposal is something that it's there, but it's discretionary. It's up to the judicial officer to make a decision and say whether this applicant needs to pay that. But in this for delaying this case, and mostly it always works on the civil side, but on the criminal side, on the criminal side especially, those are things that it sometimes largely it affects government agencies, including the police, and even the way the prosecutors do their work. So that looser pay proposal needs to not be only on the civil side, but also on the criminal side, so that if somebody's matter is delayed over time, they can be able to recoup that. Lastly, the importance of, we emphasize this, and the key message that we would like everyone to carry is that it's not just the budgets alone. It's not just the resource problem. So like when the small claims court was introduced, you see case resolutions on certain specific questions like a certain kind of disputes has gone up, and that pendency is even lower and is even lower. So we think that that is the key thing that we like people to carry, and we don't endeavor to take your feedback and synthesize that and inform our future studies. Thank you.
Thanks, Leo. as we take the final round of questions, I think there was also something there's something you can respond to later in your second response regarding whether we've considered disaggregating the different categories of cases and how they contribute to the case backlog problem. So in terms of criminal and civil suits, I think there was also a question about, I think, the children's division and other different divisions and how they contribute to this and where resources are focused. And yeah, so we could just provide us a brief response to that. If I don't know if anyone else would like to ask a question orally, please raise your hand and we'll allow you to ask. Anyone who would like to ask a question verbally? So as I do not see any hand, I think, yes, Leo had already attempted a response to Migu in terms of the bit on if we had the ear of the Chief Justice and the Attorney General, what policy recommendations would make. So I'd add to what Leo has said, or just restate that the three things. First, from what we've presented and what we'd be recommending, the question of, with regards to the question of timelines, I'd say that there is need to institutionalize mandatory timelines. So if the statutory framework at the moment clearly does not facilitate the timely resolution of disputes, there's need to either enact statutory or regulatory timelines, stating very specifically, say, for instance, 12 months for civil cases, 6 months for minor criminal cases, so within which time this certain disputes should be resolved. This can be backed by some regular monitoring and reporting to either the JSC, the NCAJ, and I think it would create that culture of accountability and urgency that is currently missing. We say this very aware that there's already a big backlog problem, which, as we have projected, would require, if proper timelines are, if proper measures are put in place, we can have a focus of dispensing this off in, say, 5 years, for instance, but going forward, there's need for institutionalized mandatory timelines for that resolution. A second thing is, how do we resolve the question of adjournments, cap these adjournments, and enforce penalties? So either amendments to the Judicature Act to cap the number of adjournments allowed per case, and regardless, just create a sense of urgency and disincentivize completely the need for any of the parties calling for adjournments, and then also impose costs or consequences for inordinate delays. That's the second. Then the third is think about the judiciary. I'd advise the judiciary to think about how to equitably allocate the resources based on the caseload and the distribution of cases. So the judiciary should adopt data-backed or data-driven resource allocation framework that considers the distribution of cases, and basically to ensure that the human resource, the judges, registrars, the infrastructure that is deployed to different places matches the case burden in these places. So those three things. And then you also asked about how the case backlog issue disproportionately affects vulnerable populations. And yes, of course, it does. From our assessment and different studies, and just basically looking at the economic data and on different cases that are filed, we've seen that vulnerable groups, the lower income litigants, obviously have lack the financial resilience to withstand this prolonged delays. So in terms of legal fees, transport costs, time away from work, so cases filed or that concern women or lower income groups, they tend to obviously have justice denied because some of them either abandon the case at some point where they're seeking redress from the courts when it's prolonged, and some tend to actually turn to informal mechanisms for dispute resolution because they are not able to afford the processes that come with the formal judicial process, and there's the kind of justice, actually they do not get any justice from the informal processes. Most of it, as we know, the systems, the cultural systems tend to not be in favor of women particularly, and other disadvantaged groups. So I guess in effect what we are saying is that the judiciary and all other parties here should think about the backlog problem not just being a question of like constitutional fulfillment. It's think about the greater social justice questions that come with addressing these issues. So I'll also add my email to this, but Leo, you can add some responses here as you make your final remarks, because I don't see any other questions. And if there's anything else that we had not responded to, please, you can talk about it now.
I already had the email. So the when you look at the resource allocation, we as economists, we tend to think in terms of supply and demand. You are meeting that, you have to meet demand. So you are supplying that public good, which is judicial access, which is courts, and so that's why we are bringing this aspect of saying, when we actually looked at that data in the SOJA, the subsequent SOJA did not capture the State of Judiciary annual report, did not capture that data, because we want, that's a data line that can be collected that shows a very good trend line. If we want the judiciary to think in terms, when they are planning resource allocation, to not just do resources by prioritize resources where there is the burden, and that burden can be used to deal with that. On the question about vulnerable populations, so one of the things of the ideas is if you look at, there's need to be more broad thinking around legal aid, but legal aid should not be offered under the auspices of the judiciary. That should be done through now Parliament thinking and creating the office of the public defender, and you can call that per se, and giving that office resources, and then competitively actually bringing that, because the judicial function, those incentives clash again, because the judiciary to again procure lawyers similarly, and the office of public defender is to go hand in hand with the ODPP, and we think that institutional structure would be more would now allow it to be bigger and gain independence and that autonomy, so that the AG comes in under those public and now comes in only to do the things that as provided in the Constitution, So we want to think, because what is the problem? What is the big issue now that you see? If you have seen experiences, if you walk now to industrial area remand, you'd hear people of cases from people who have, just to give an example, of people who have issues related to just raising bond or lack of legal representation. They do not understand those charges to all manner of other things. So that in itself, because, and I've seen the response from Dung, but the general thing is for those incentives not to clash. That in itself needs to be considered, and that service should not just be within specific areas, but be a national service, and where Parliament can not just monitor and look at those and many other things. So I've seen another hand. Perhaps Jack, you can take that question before.
Okay.
Okay. Oh, been Lord. Okay. So
I don't see it.
okay. It has been Lord. So in the end.
Okay, sorry, Tolu, would you like to very briefly unmute yourself? Sorry, I don't hear him. Tolu? Okay, I think because of time, Leo, we can just proceed.
Yeah. So in the end, we'll continue to look at these other factors. We'll circulate the study after the
Hello,
meeting.
good morning.
Thank you.
Good morning. Can you hear me?
Yes.
Oh, sorry about the delays. I had sent on the Q&A, but I am not sure whether it was read. So I sent the questions on the Q&A about 11 minutes ago. So maybe you can look at the Q&A and if it's not possible to take the questions now, we can take it later, maybe in another forum. But I sent the questions. I had just 3 issues that were raised. That I raised earlier, and I'm not sure whether it was addressed in the report. Yeah, it's basically on repeated cases, frivolous cases that have been filed regularly. The question about the mediation program in the judiciary, and the fact that we have about 8,400 mediators that can actually resolve most of the cases, especially the civil cases, within a record of 12 months. And I think the last challenge, or the issue number 3 I raised, is the question about the correlation between case backlogs and low-profile cases that have been filed regularly. The incentive structure is very strong. So except we were able to actually resolve the incentive structures, we will not be able to resolve backlog of cases. Because right now there are selected groups of lawyers, arbitrators, judges, magistrates that are being indicted, and you could notice that from the complaints that have been filed with the GSC. So these are just the 3 issues I raised earlier. Thank you for the time given and good report. Thank you guys for the work you've been doing all these years. Thank you.
Okay, thanks. Leo, maybe you can respond to him and as you actually close, make your closing remarks, yes.
Yeah, so questions being refiled in lower courts and that have already been determined with finality. I think largely that issues that have been dealt with finality being refiled again wouldn't, based on rules, practice rules, should not be filed again. But the legislature working with judiciary not promptly pay an increased fees for over 1,400 accredited mediators. Remember, mediation is one aspect. There is also because what we are discussing here is the judicial access, and that judicial access is the one that is funded and provided for in public. But the issue of, because here the question about payment or remuneration payment or remuneration is not something that affects performance, because it's not something that largely would say, because here our only focus of the study was on the question on the question of access, that access that is provided by that should be funded, and the one that the Constitution requires under Article 159. But we recognize that AJS alternative justice system is also part of Kenya's Constitution. And one of the things that we noticed is in the literature review, we found out that some firms like that there's a concept in the US, so it's called Modria. There are others in Canada called like Smart Settle, and it came from technology firms, which had disputes, some running up to 60 million. So they were solving a big number of disputes between sellers on the eBay platform, between the buyers and sellers on that platform. And that now, as people brought it as a public question, how can this kind of a feature be brought to help with that? So I think that edges broadly could be considered in that. So the last issue is, so on the incentive question, our iteration is that we want JLC to think in form of incentives. We want the Attorney General as the lawyer for the Republic and a key part of the JSC to think in terms of incentives. How do you shape these incentives? We want the DPP to, when you're approving those charges, incentives, frivolous cases should be held. So the entire criminal justice system, and that in itself, penal code review, those offenses to align with now the 2010 constitutional dispensation. Remember, the penal code is a 1925 legislation. Some of those things in the penal code might not actually withstand the constitutional questions. Even the disparities in terms of fines or custodial sentences. So those things need to be rethought afresh, and to meet the dynamics whereby, because it punishes actually crimes of livestock, or like livestock, things like and the other crimes, but it's soft on blue collar and on the other crimes that cause society to harm. So that, and even the way the process of bringing those charges to court, that's something that really needs to be rethought, and that's why you're saying that part of it is the Attorney General to help with those issues. So those incentives, aligning those incentives should be a concerted effort between all these key arms of government. But the JSC in itself needs to discipline questions before they come to court, before key issues, key policy questions, rules, how the judicial officers, who are their employees, how they use their court time, how that court time can be optimized, and all the other questions. Thank you, and I end at that.
Great. Thank you. Thanks a lot. So we'll end at that. Thank you all for being here. We spent an extra 18 minutes. So thank you for your time and for considering this useful. We hope that what we have shared has provided some useful insights. And please feel free to engage with us further if you have any additional comments or suggestions, a write-up that you can suggest to us. You can feel free to share that. So the presentation that we've just made here will be available on the IEA's website immediately after this meeting, as well as the paper that we have written. As we've mentioned, there are some aspects of it that we will refine in future, and include some of the proposals that have been shared here. So that we'll have like a second version of it. But for now, the first draft of the paper will be available on the website shortly. So thank you all again for being here. For those of you who are here and you're not IEA members, the IEA is a membership institution, and we are very open and glad to welcome you to be an IEA member. Just reach out to our communications department, and Oscar and Michelle will be able to help you to, or rather guide you on how you can be a member and what your benefits would be. And then please look out for other IEA webinars and other meetings through our social media platforms. You can follow us on Twitter at IEA Kenya and all other platforms, and let's keep the conversation going. We are in the budget season, and we will be having a couple of discussions related to this year's budget. So please look out for that on our Twitter. We'll be having a Twitter conversation very soon, as well as other webinars. So please look out for that and participate. So thank you to all of you who've participated in this.